Todd, what are the talcum powder cases about, and why was there a bankruptcy trial against Johnson and Johnson? So I just want to sort of start at and create a foundation.
Sure. So the allegations of talcum powder. So talcum powder, we're talking about baby powder. We're talking about what, everybody's parent in the United States used on them as a baby, but also that many women and men use as a hygiene product. Right. All over their body, usually right after they've taken a shower, for a variety of reasons, to control wetness, to control odor, to a variety of reasons. So this is a product that's been used for over 100 years. And from a company that has prided itself on being a baby product, being, America's product, everybody has it in their home. So the problem came about when Johnson & Johnson decided to test their product for asbestos in a way that would not reveal asbestos in the product. That's really what this case comes down to. So asbestos, as everybody knows, is a carcinogen. It's been designated as such since the mid-50s. And a lot of people know the history behind asbestos litigation.
Right.
This is a horrific mineral that comes out of the ground that has a fire retardant product to it, manner to it, so it was used in a ton of products. And then lo and behold, it came about that it causes something called mesothelioma. It can also cause lung cancer. So that mineral, talc that's in the talcum powder, that mineral, according to geologists, cannot be mined without mining asbestos at the same time. The two coexist in nature. So you can't separate them. You can't go drill in this hole and get talc and go and drill in this hole and get asbestos. They're intertwined. So Johnson & Johnson, for years, tested their materials in a way that the easiest example, and I'll get it wrong, is, but Mark Lanier had a good example in his trial, where he took a very highly sensitive scale and put a needle on it, and it registered the weight of the needle. Then he took like a regular bathroom scale and put the needle on it. And of course, nothing's going to show. No needle's present because it doesn't weigh anything if you're looking at it on a bathroom scale. So the problem is, the science says you only need one exposure to asbestos for you to be able to develop mesothelioma. That's it. And so for them testing in a way that they didn't have to report that there was asbestos in their product, they could say it was 100% asbestos free. That's really what this case is. Well, so as this case is developed, it became clear that asbestos can also lead to ovarian cancer. And so now you not only have the exposure that you would have using it as a hygiene product, but you also, when you're putting it on, when you're putting it on your baby, the dust, you're also inhaling. And so you have a mesothelioma problem, you have a lung cancer problem, arguably, and you have an ovarian cancer problem. So that's kind of how the litigation developed. As David pointed out, when this litigation started, there weren't a whole lot of cases. And then Johnson & Johnson was forced to disclose certain information through the discovery process. And it became apparent that this is what they were doing in the way they were testing this product. And so their product was not asbestos free. Numerous tests and studies were done where they went and grabbed bottles off the shelf and tested them, and there was asbestos in them. That's how the process came about. There have been numerous trials on the ovarian cancer side.
Right.
The most famous one being Mark Lanier's $4.2 billion case in St. Louis 4 years ago now. There have also been numerous mesothelioma verdicts over the years, on an average of about $36 million a piece. Some of them have been much lower, some of them have been much higher. So Johnson & Johnson, after numerous tactics, They tried to go through another bankruptcy trust, the Emerist Bankruptcy Trust. Emerist was their supplier of talc. They tried to get relief through that. They tried to get all of the experts thrown out in the MDL through a Dahlberg challenge. They've tried appeal after appeal after appeal, some successful, some not. And so this became what they deemed internally as Project Plato, where the law firm of Jones Day went and pitched what we're going to refer to as the Texas two-step to Johnson & Johnson and said, you can take Johnson & Johnson Consumer Inc. They're the ones who hold the liabilities for the baby powder. Take JJCI, which is what we call it, go down to Texas, open the corporation there, do what's called a divisive merger. Out pops a company that holds the liabilities and one that holds the assets. Take your asset company back to New Jersey, where JJCI came from, and make it new JJCI. Take your company holding the liabilities and take it, we're going to rename it LTL for Legacy Talc Liability. We're going to take that, we're going to put it in North Carolina in a favorable bankruptcy court, and we're going to bankrupt that company. And so all those liabilities are going to be held in LTL. And we're going to claim that we have to do this because the liabilities are so substantial that they make JJCI insolvent over if you take in current and future liabilities.
Right.
So that's how we ended up in the bankruptcy court. And then from the bankruptcy court, the judge in North Carolina correctly saw that this doesn't belong in North Carolina, it belongs in New Jersey. And so the case was transferred up to New Jersey. And then in New Jersey, the trustee split the case into two committees, one for ovarian cancer and one for mesothelioma, because those processes, those arguments, the diseases themselves are pretty unique. And so the trustee thought that made the most sense. And so the motion to dismiss trial that was held in the middle of February was prosecuted by the Meso Committee and the Ovarian Cancer Committee.
Right.
And so that's how we've got to where we are today.